Have you ever wondered if you are fully protected by the Constitution when you are just out and about, maybe walking down a street or attending a public event? It is a question many people ask themselves. The Fourth Amendment, which protects us from unreasonable searches and seizures by the government, generally does not apply in public spaces where you have no reasonable expectation of privacy. This means what is willingly exposed to the public is not protected by the Fourth Amendment. The core principle guiding this understanding comes from a landmark Supreme Court ruling in a case called Katz v. United States. The court established what is known as the two-part test for a reasonable expectation of privacy. First, an individual must have exhibited an actual subjective expectation of privacy. Second, that expectation must be one that society is prepared to recognize as reasonable. If you are in a place visible to the public, like a park or sidewalk, or even engaging in activities that can be easily observed by others, then generally you do not have that reasonable expectation of privacy, and therefore the Fourth Amendment's protections do not apply. Understanding this standard helps clarify how government actions are assessed in public. For instance, police officers can observe and photograph you in public or record events in public areas without needing a warrant. They can also seize items that are in plain view, meaning readily observable without needing to conduct a search. This concept extends to things like trash placed on the curb for collection, or even conversations shouted loudly in a public street. These situations typically fall outside the Fourth Amendment's protection because there is no reasonable expectation of privacy. It is important to differentiate this from areas where a reasonable expectation of privacy might still exist even if they are not entirely private. For example, the legal concept of the open fields doctrine clarifies that undeveloped or unoccupied land outside the curtilage of a home is not considered a protected area under the Fourth Amendment. However, specific activities or locations within public view, such as the interior of a public restroom stall, might still invoke a limited expectation of privacy. This is where the nuanced application of the Fourth Amendment truly comes into play, requiring a careful balance of individual rights and public safety concerns. Ultimately, grasping the concept of a reasonable expectation of privacy is key to understanding your Fourth Amendment rights. While much of public life falls outside its direct protection, knowing these boundaries empowers you to understand what governmental actions are permissible and when your constitutional protections may still apply.